Morning everyone, welcome to our webinar on preserving land and buildings in perpetuity via charitable trusts. Thank you for joining us. Let's just do a quick introduction. My name's Hannah Harbottle. I'm one of your speakers today, and my colleague Louisa, who you can also see on the screen, Louisa Saunders. We're going to be running through some of the ways that you can preserve land in perpetuity via charitable trusts. So the first thing we're just going to run through is why you might want to do that. And there's various reasons that we often come across. So one of the most obvious one, and one of the most topical ones, particularly at the moment, is preserving land for a conservation or a wildlife benefit. This could also be for community use, so you think of community spaces, village halls, etc. You might also want to preserve land in order to prevent or delay development. If you've got some garden land or some woodland that you want to preserve to make sure it's not going to be snapped up by a developer. There's also the potential for preserving value in adjoining land. So there's a similar sort of example. If you've got woodland or large areas of open space adjoining your land that you own, in order to protect your adjoining land from development for the future, you might want to preserve that adjoining land against development. And then the last point, and not something we come across as often, but it's for historic purposes. So you think of art galleries, for example, or much of Stratford on Avon, for example, is preserved for the Shakespeare's museums. So I've just touched lightly on this, but what sort of property you might want to preserve? As I've said, things like woodlands, museums and art galleries, village halls and buildings that have community benefit. Village greens are still quite a common thing. The traditional cricket pitch in the middle of your village might well be protected against redevelopment, and parks and public recreation land. So everybody's aware of National Trust land, for example, that's protected for public use. So what can you do in order to protect that land in perpetuity? Well, there's various methods that you can adopt. Either by retaining the land yourself or by disposing of it. So we're going to run through these 5 sort of key points that you can use. So sales, if you're selling the land off but you still want to restrict its future use, you could think about incorporating restrictive covenants or overage obligations within the transfer terms in order to retain some control in the future. If you want to retain ownership but you do want to lease the land, for example, there are various ways that you can retain control over how that land is used. We're going to touch briefly on towns and village greens and assets of community value, which is quite a large area in its own right, so I'm not going to go into that in a huge amount of detail, but that is an option for protecting land. And then there's also what we're calling guardian organisations. So there are some organisations that will take on responsibility for protecting land, or you can designate land to guardian organisations so that it can be used for public purposes and it's preserved against development. And then Louise is going to talk a little bit about setting up a charity or leaving land as a legacy gift to a charity in order to preserve it for charitable purposes in the future. So we're going to talk first about sales and leases, and Louisa is going to run us through the options that you can use for sales and leases and preserving charity land.
Thanks, Hannah. So yeah, talking a little bit about things you can perhaps do if you are disposing of some land, but you want to restrict what the next person can do with it. So a couple of the things you might think about are covenants in the sale documents. First of all, thinking about restrictive covenants. So, for example, you might say, I will sell you this piece of land, but you must not use it otherwise than as garden land, for example. And that is done to perhaps stop somebody building on that in future. Now, there are some things you need to bear in mind when you're thinking about restrictive covenants. They're all about land. That's the first thing. So although they look a bit like a contractual obligation in the documents, saying that you will not do something, they are supposed to protect the utility value of land. So there are some rules around creating valid restrictive covenants. There must be a piece of land which benefits from the covenant, and that must be land that you are retaining yourself in order for that restrictive covenant to attach to it. There are some exceptions to that, which we'll talk about a little bit later on in some of the guardian organisations. But generally, you must retain some land. Restrictive covenants are restrictive and negative in nature, so it's about not doing something on the land. Positive covenants are treated differently, so making it a condition that somebody does something is more difficult to achieve. There are some ways in which restrictive covenants can be challenged as well, so they're not necessarily a fail-safe, whilst they look quite simple in documents. So, for example, if the two pieces of land ever come into the same ownership, the restrictive covenants will fail because they are, as I say, a land thing, and they need two separate pieces of land, one which is burdened by it and another which has the benefit. So if somebody in the future was to buy both pieces of land, that could then destroy the restrictive covenant. They have to be drafted in the right way. It needs to be clear which land is involved. So we need proper plans and things. If they're not drafted in the right way, then they could be open to challenge in the future. The other thing to mention is the Lands Tribunal, which does have the power to remove restrictive covenants over land. And this comes from a general principle that the law tries not to tie land up for perpetuity, because it recognises that over time things need to change. And so if somebody goes to the Lands Tribunal to challenge a restrictive covenant, they might be able to get that released if they could say that, for example, it serves no valid purpose. So if it doesn't protect the utility value of some land, for example, or the other thing is if it would impede a reasonable user of the land. So in 100 years' time, if some land is a housing estate, it might not be realistic to expect land to be tied up in a particular way. And so there is that ability to get the Lands Tribunal to release that covenant. The other thing is that in the future, people could come to an agreement that the covenants are released between themselves. If somebody is clearly the owner of the benefiting land and someone else is the owner of the burdened land, they could agree a mutual deed of release. So, and there's not that much you can do to stop that, but it can be quite difficult to achieve. Also, it is common for land to be burdened by restrictive covenants, and we do often advise that, in fact, although a restrictive covenant is there, it doesn't necessarily stop land being developed or the use changing in reality, because it's quite common for a buyer to proceed with their plans with the backup of an indemnity insurance policy, which will often enable, for example, someone to build houses even though there is a restrictive covenant on the land. So they are not the perfect solution, but they can be a good tool. Possibly there's something for more of the immediate future rather than looking in perpetuity. And the other thing we've mentioned is overage, which can be called different things. Sometimes it's called clawback or development uplift, and that is more of a contractual creature. That is securing a financial payment from a future change of use or development, and that can often act as a disincentive for somebody in the future to develop land. because again, if it's all set up in the right way, it may be that there is then no profit to be gained from a development, for example, if you're going to have to pay half of it or 3/4 of it to a previous seller. So that is often used in sales of land where there is possibly some development potential, but people want to ensure that either that they get their share of that value, or to try and make it less attractive for someone to develop the land. So there are a couple of ideas on what you might do if you're selling land and want to restrict what the next person can do with it. Another alternative, which isn't discussed all that often, is rather than selling land freehold, putting a lease in place, which can be anything up to 999 years. So rather than relying on freehold covenants, such as restrictive covenants, which have difficulties in enforcement, firstly because of perhaps the way they were drafted, and then secondly, perhaps in proving that you have the right to enforce that restrictive covenant, and because they attach to land, what you could potentially do is grant a lease of land. So, for example, if you were to have a woodland, maybe you could grant a lease of it rather than selling it. And that is going to give you much more direct control, because the nature of a lease is that it is a land contract between the parties. And although potentially the tenant under the lease could change over time if the lease allows it, there is always what we call privity of contract there between the parties, and it makes it much easier for a landlord to enforce covenants against a tenant than it would be to try and enforce covenants against land where you have parted with your freehold interest. You can specify essentially whatever you like in a lease of that nature. They're not commercial leases are not really the same as residential leases. There is not a sort of set of standard terms. So you can put provisions in there about whether the land can be transferred to a different tenant in the future, whether changes can be made. And if you want to impose some positive obligations, ensuring that the tenant does certain things, that is also a lot easier to achieve via a lease. Because the ultimate sanction is that if something is the breach of the lease, potentially a lease can be forfeited. So that is worth considering, although we appreciate that it's not necessarily going to be right for every land sale where one is trying to actually achieve some value from the land. I'm now going to pass on to Hannah, who is going to talk about some other interesting options for protecting land via some guardian organisations and also the assets of community value regime. So Hannah, over to you.
Thanks, Louisa. Yeah, so if you don't want to sell your land or grant a lease of it, what else can you do to try and preserve that land against development, for example? So there's a couple of alternative options. As I said, I'm not going to go into a huge amount of detail about common land, towns and village greens and assets of community value, because it's quite a wide area in itself, but it is an option to consider using, either registering land as common land or town and village greens, or having it registered as an asset of community value. So the first one is common land and towns and village greens. So if you think of, as I mentioned earlier, your classic cricket pitch in the middle of a village, or you often hear about common land used historically for grazing. These are open spaces that are protected by registration, and whilst it's not impossible to do things on those on that land, you can, for instance, apply for consent to install essential services through, if you're trying to connect something to your adjoining land, and you do need to run services through, and there's no way around. You can apply for consent to do work on that land. but it's extremely difficult and time consuming and costly to go through that process. So that land is protected against redevelopment to preserve the integrity for the community use. The other option, which more people have come across, is assets of community value, which often you see with pubs, sometimes post offices, restaurants in villages. You register the building, it comes up on your local authority search whether the property is registered with the council as an asset of community value, and it essentially gives the community a right of first refusal. If you want to dispose of that site, you have to offer first to the community. It creates a time window during which you can't dispose of the land while the community decides whether they're going to club together and exercise their right of first refusal, essentially, and purchase that asset, whatever that may be. You see this sometimes with village halls as well and community centres. So it's an option. Obviously, it doesn't prevent that land if the community can't club together, can't find the money, or doesn't want to, then that asset can go on and be sold for whatever it's intended to be sold for. So it could be for redevelopment, but it is there as an option in order to preserve the integrity of a lot of the villages. There's obviously been a huge amount talked about in the last decade or so about villages losing their pubs and community centres, etc. That's a way of trying to retain those assets for the community to keep the village feel of it, and that ties in with the common land registration as well, where you keep your green spaces, usually in the centre of the villages, preserved against development. So that there's an option there for two ways of potentially preserving land or a building asset, in order to either restrict completely or give you an option for purchasing instead of an asset going on for redevelopment. So you see that used quite often, as I say, primarily with things like pubs and community centres. Something else that you can consider instead of a sale or lease is to use a guardian organisation. The two most common that we come across are Fields in Trust and National Trust, which most people will have heard of. So Fields in Trust is what we're calling a guardian organisation, where you can dedicate land to them, usually for public use, where you're specifying that this land can only be used for a specific purpose, which is usually for community use as public open space. It might be woodland, it might be playing fields, it might be children's play area. And what this does is it essentially creates designated land, which might be an expression that you're familiar with charity land. So it restricts the use of that land in perpetuity, so that it cannot be used for another purpose or go on to be redeveloped without jumping through the hoops of obtaining consent. So designating land to Fields in Trust in particular is quite effective in protecting that land, because Fields in Trust will specify quite restrictive uses on that land, and it can be difficult, if not impossible, to get that back, to get that designation off the land. They will often specify that they need alternative replacement land if you do want to dispose of it, so that they're preserving for the community a certain area of land, and if you do have to switch that for whatever reason, they will want an alternative site. So it can be quite restrictive, and in that sense, it's quite effective in protecting that land. It's often used by local authorities, we see, to meet their public space requirement, where they have to designate a certain amount of land for public use and public recreation. They quite often will designate land to Fields in Trust. And a similar process can be achieved with the National Trust, where they can enter into agreements where you restrict land for either a specific period or in perpetuity, restricting its use, again, usually for public open space or for wildlife or conservation benefit. It can be used to restrict planning and development on the land in future. And the benefit of the National Trust scheme is that if if you haven't got benefiting and burdening land, so you can't meet the requirement of a restrictive covenant, which Louisa was speaking about earlier, it is possible to enter into one of these agreements with the National Trust, for example, and you don't need to meet that requirement for the restrictive covenant, so you don't need to have two parcels, one of benefit and one of burdening land. So it's a useful backup if you can't meet that requirement for a restrictive covenant. You can think about one of the guardian organisations, and there are others out there. These are just two that we've picked up on as an alternative to doing that. So one of the other options that you can also think about is conservation covenants. And again, I'm not going to go into this in huge amount of detail because it's quite a wide area, and we have done a specific webinar on this previously about how conservation covenants can be used for charitable purposes and to protect land for charities, particularly for wildlife benefit. So briefly then, conservation covenants are an extra option that you can consider. So it's a private agreement between a landowner and what we call a responsible body, and a responsible body can't just be anybody, but it's somebody who's been approved and registered with the Secretary of State for Environment, Food and Rural Affairs. So we're starting to see this come out as local authorities, the National Trust, for example, charities and companies can put themselves forward to be registered as a responsible body. They must have their conservation, their main purpose must be for conservation, apart from the local planning authority, who obviously do a wide range of things. So there is a bar to meet before you can be registered as a responsible body. You have to be able to show that it's for altruistic use, for heritage sites, for ecosystem mitigation, or for biodiversity net gain. And it must also be, the intention must be for it to be for the public good. So there are a few hoops to jump through in order to meet this, to be registered as a responsible body, but it is a useful way of entering into an agreement with a landowner where you essentially specify conservation covenants on the land, so what can and can't be done on the land for conservation purposes and for conservation gain as well. So you can specify active steps that must be taken in order to improve the wildlife benefit, for example, on that land. And the benefit of conservation covenants is that they run with the land, much like restrictive covenants. So they are registered against the title, and they run with the land and will bind a successor. So there is that benefit there. And interestingly, for charities, the great thing about conservation covenants is that you don't necessarily have to have an interest in the land. If you are a responsible body, you could take on the responsible body role for land that you don't have a connection with, but that you are interested in preserving and promoting for conservation purposes. So as I say, it's quite a wide area. It's quite a new area that is evolving at the moment, and we haven't seen a huge number of examples of this coming out, but it is starting to grow. So it'll be interesting to see how that develops. But it's an option where you don't have the interest in land, or you can't sell or lease, or you can't meet the requirement for normal restrictive covenants. You can think about conservation covenants, albeit you'd have to go through the registration process to be a responsible body in order to benefit from that. So Louise is going to talk a little bit about how you can set up a charity or gift land to a charity in order to preserve it for conservation purposes or in perpetuity, and some of the tax benefits that you can get from that, which is always a bonus.
Thanks, Hannah. Yeah, so I must caveat that by saying I am not a tax lawyer, but thought it was worth just highlighting some of the tax advantages that there are in giving to charity, and that applies to land as well as cash. So if you have a piece of land and you want to make sure that it continues being used as such for the future, say it's a piece of community woodland or something like that, how might you do that? You could potentially talk to a suitable charity and think about gifting the land to the charity for them to safeguard it for you for the future. So that might be a local village charity, your local playing fields charity, or it might be a much larger, perhaps a conservation charity, for example, depending on the piece of land. Best to talk to the charity, obviously, and make sure they want to receive the land and if it fits with their objectives. The advantage of potentially transferring land to a charity is that you are then into the charity land regime and the various restrictions that the law puts on land held by charities. Land by charities has quite a special status, and that's a sort of historical thing, really, because years ago land would have been a very important asset and one of the main assets a charity had, and therefore there is a lot of red tape involved in making any disposals of charity land. You could attach certain conditions to a gift of land. So you could say in your gift of the land that it has to be used for particular purposes. Again, I would encourage that you speak to the charity and ensure that everybody's on the same page with that. But you could, for example, say, this piece of woodland must be used for the purposes of the local village charity for the benefit of the conditions of life of the local residents to use as recreation. And by doing that, it makes it more difficult for the charity to make any disposals of it in the future. Generally speaking, before a charity can make any disposals of a piece of land, the governing document would need to be checked and to ensure that there's nothing in there which restricts the sale of land. So that's one element of protection that would exist. Any sales must be in the charity's best interest because the trustees are under duties to only act in the charity's best interest. So that also helps with potential disposal. If land is designated, so that is a form of permanent endowment, and it means that it's held for specific purposes of the charity. For example, the charity is there to provide open space for the local residents. That brings it into an extra level of protection. Where that's the case, usually the land can't be disposed of unless it's being replaced with equally suitable land. There also would need to be a public notice procedure, so the local community is told of the proposed sale, and that gives people the chance to not stop the sale, but to lodge objections and ask for further information. So it is quite an involved procedure to try and dispose of land which is subject to those restrictions, and that does help with trying to make sure that that land is kept for the future. Couple of the tax benefits, I have set these out on the slide, and I'm not a tax expert, but essentially you can get relief from income tax if you give to charity, and that applies if it's land or if it's money, so worth checking out. If you are going to leave land in your will, it may reduce the inheritance tax on your estate as well. Clearly, you'd need to take advice from a suitably qualified professional advisor on that, but it is definitely something worth considering if you have land which might qualify and if you stand to have a large tax bill. Another option is possibly you have an idea of setting up your own charity, and that is something that we do all the time. So maybe you don't quite trust the local charity that that they're going to do what you want them to do, or you don't really want to give the land to a very large charity. You'd rather have your own charity, which is set up specifically to manage that piece of land or that interesting building for the future. So what is a charity? Well, it is all about what the charity does. Charities can take different forms. They can be trusts, companies, They can be a charitable incorporated organisation, but it's all about what they do. So a charity must have a qualifying charitable purpose, and those are set out in Section 3 of the Charities Act. So just to pick out a couple of legal charitable purposes, you've got education, you've got amateur sport, environmental protection, arts, culture, heritage, recreation. Alongside having a qualifying charitable purpose, you must be working for the public benefit. So you can't be, having a lovely area for your own personal recreation. It must be there to benefit the public. So that is essentially what a charity is. I've put a couple of bits there about tax again. Just be careful with what I said about making things tax efficient, because there are some clever wheezes around designed to take advantage of those tax reliefs. And generally speaking, they have been unravelled. Setting up a charity should always be done with the charitable purposes in mind, and not to try and get any sort of personal benefit from the arrangement, because that will usually just end up failing. And we would always advise that professional advice is sought before you think about setting up a charity, because there is obviously a lot of work involved. But it is an option for trying to safeguard land and buildings that you want to see preserved for the future. So we've gone over the half-hour mark. We better go on to our questions. We might not have time to answer all of your questions, I'm afraid. I've skipped over one of my slides. If we could just go to the questions slide.
Yeah, we've had a few things in. Somebody's asked, Harriet, thank you, has asked a specific question about conservation covenants and how they're enforceable. As I said, we've done a specific webinar in detail about conservation covenants, so we can send you the link to that, because that's got all the information about how they work, how they're enforceable, what the remedies are, etc. for breach. We've had a question again from Harriet. Do we know when the Charities Act, the new Charities Act, is coming into force? How long is a piece of string? It is already in force. Some bits of it are already in force. The new charity land regime was due to come in force in spring. Most of us would agree that spring has definitely sprung, and that there's no sign of it yet, but you know, watch this space. We know what it's going to look like, unless they make some last-minute changes, and we know what those changes are going to be. And Louisa and I have done again another webinar on the new charity land regime and what changes we think are going to come in. So have a look at that if you want some more detail on that. But at the moment, like everybody else, we're waiting and holding our breath.
So I think we've unfortunately run out of time, because we could talk about these things all day, but do feel free to get in touch with us if you would like to talk about any of the points that we've discussed today. A couple of people have asked about the slides. So just to confirm, you will have a copy of the slides after this session, and the webinar is also being recorded, and you'll be able to access that again if you want to play back. And finally, just to say thank you very much for attending today. I hope you found it useful. There is a feedback form, I believe, which you will have, and if you could take a moment to fill that in, it would be really great. And please let us have any ideas for things you'd like us to talk about in future, and we'll try and put on a webinar for those. So thanks very much, everyone. Have a good day.
Thanks, everyone.